then, and B2 thinks good, gets the statutory assignment, then B2 later on goes to sue X, and X says, actually, you don't have priority because I already got notice from B1, what do you think the court can say to X then?
It's just negligence.
Not even negligence, really, but what would you do if you're B2? If somebody's told you something, you acted in reliance on that, and now they're trying to deny the truth of it, what would you do? Yeah, good. It's an estoppel by representation. You say, you represented a matter of fact. You said this fact was true. I then relied on that by going ahead with the statutory assignment. I would now be worse off as a result. So as a matter of common law, as a matter of evidence, I can stop you from denying the truth of your earlier representation. That's just a standard estoppel by representation. Okay? So you could do that. I mean, if X just said, I'm not going to tell you, if X said, I'm not telling you either way, it's private, then I don't think there's anything B2 could do then. They just have to either go ahead with a statutory assignment or not. I don't think they could force X to tell them. I mean, normally, obviously, if they don't know about the earlier actual assignment, then they'd probably have a claim against A, because, you know, A should be telling them about the earlier actual assignment. But the problem is, if A's insolvent, then claims against A aren't much good. Then they'll want to try and claim against X. Now, obviously, they'll have a problem if X is insolvent, but then that's always going to be the case. If you're taking an assignment of a contractual right against X, if you're taking an assignment of a debt against X, you're always going to be in trouble if X goes insolvent. So you can't really complain about that. Okay? Right, so this point about concepts and context, this is also quite important when we look at restrictions on assignment and limits on assignment. It's worth thinking about in relation to that as well. So how did you get on with looking at the lecture cast of the lecture? Did that work all right? Technically speaking, it worked all right? Good. My one worry with those things is that I'll have been wearing exactly the same clothes when I did the lecture in the previous year. But I didn't check. So this is why I can use my research allowance to buy new jumpers each year. But good. So that means we can crack on a bit talking about this stuff and focus a bit more on the new stuff. Now, were there any bits? So from the handout, say, I can't remember what. Did I talk? Was this stuff in the lecture cast? No, I didn't think so. It wasn't. Are you sure? About limits on the rights of the assignee? Okay, I didn't think so. Right, so I'll talk about that briefly. So this bit, limits on the right of the assignee. This isn't too important, but it's just worth being clear about. So what you can't have with the X with assignment or the statutory assignment is it can't put X under a liability that's greater than the liability they'd have been under to A. Okay? A good example, that's the Dawson and City Railway case. So there was an assignment to B of a statutory claim against the railway company for interfering with A's land. So the railway company had interfered with A's land. You know, to build its railway, they're allowed to do it. So the statute said they could build the railway, but they have to compensate the landowners, the neighbouring landowners. So when A sells the land to B, they also assign the benefit of that claim, which is fine. But then what B wants to do is impose a greater liability on X, on the railway company, because B's using the land in a different way from the way that A was using it. So B's suffering additional loss because of the interference with the land. So they want to recover damages greater than what A could have recovered. And the Court of Appeal says, no, you can't do that because it's an assignment, but what you're getting is A's right. You're getting A's right against X. So you can't impose a liability on X that's greater than the liability X would have been under to A. Okay? And that's sort of summed up later on in the Court of Appeal in Linden Gardens by Lord Justice Staunton. B can't recover any more than A could have recovered if there'd been no assignment and if there hadn't been a transfer to B. Now that bit in italics, and if the building hadn't been transferred to B, that was important later on in this Offahoor and Larkstore case. Because this was, in Offahoor and Larkstore, X wanted to use the fact of the assignment to reduce X's liability. Okay, X wanted to use the assignment to reduce its liability. And it was quite cunning what they said. This was a case, sort of standard case, where X was the contractor and they'd been negligent. So they had, let's say, they were meant to clean up A's land and they'd done it carelessly. Well, they were meant to build something, they'd built it carelessly. You can get it on lots of different sets of facts. So X messes up, but X's breach isn't obvious until a few years later. And by the time X's breach becomes obvious, A has already sold the land. Okay? So A sells the land to B, and A also assigns any rights they have against X. Then it turns out that X was in breach, and that's now causing B loss, the same sort of loss that A would have suffered, and so B wants to sue for it. Then what X says in Offahoor and Larkstore is they say, well, you, B, you can only recover what A could have recovered. And A can't recover anything because A sold the land for full value before it was discovered that I'd done anything wrong. So A hasn't suffered any loss because although, yes, I breached the contract, it didn't cause A any loss because A was still able to sell the land at full value. So obviously if A had still been there, A could have sued X and got compensation. But X is now trying to take advantage of the transfer to say they're not going to be under any liability at all. And obviously the Court of Appeal doesn't like that. They say you can't do that. They say the point of the principle is to stop X being under a greater liability because of the assignment. X can't use that principle to escape any liability at all. Okay? So what you do is B is allowed to sue for the breach, and you're treating them as though they were A. They're not allowed to get additional damages beyond what A would have got, but you treat them effectively as though they're in A's position, and X's liability is calculated accordingly. So X can't benefit from the assignment in the way they were trying to do in the Offahoor case. Okay? And again, this is an important difference between assignment and novation. In a novation, you have a completely new contract between B and X. And if there's a new contract between B and X, then B can just enforce it, and if B suffers lots of extra loss, B can claim that extra loss because they've just got a direct contract with X. But with an assignment, it's still really A's right that's being enforced. So that's why there are these limits on what B can recover.
So it's B that can't benefit from the assignment in the way they were trying to do in Offahoor?
No, in Offahoor it was X who was trying to benefit from the assignment. In Offahoor, X was trying to say, well, B's suing us, but they can only recover what A could recover, and since A managed to sell without any reduction in value, A can't recover anything. So X is then trying to get away with paying nothing at all. Whereas in Dawson and in Linden Gardens, X just wanted to make sure they didn't have to pay more than they would have had to pay to A if there hadn't been an assignment. And that's okay. We can sympathise with that. But we don't want them to use the assignment just to get away with paying nothing. That would be a bit much. Okay? Right, so I mentioned set-off briefly, because that set-off is sort of relevant when we look at the stuff about restrictions on assignment. Do you know what set-off is? You're not expected to, really.
It's mutual debt. So one person owes a debt to the other person, and the other person also owes corresponding debt to the other person.
Yeah, good. So it could be that, I carelessly run you over, so you want to sue me, but you also owe me some money anyway. So when you sue me, I then say, okay, well, I'll give you the money, but minus the £1,000 that you owe me, that sort of thing. And why is it quite useful sometimes for the defendant to be able to do a set-off? How does it help them?
They don't have liquid funds.
Pardon, because?
They don't have liquid funds.
Well, you could say, well, look, we're not going to have set-off. We're going to say A has to sue B, and then B has to sue A, and we're all going to do it separately, just separate things. But why would that be worse for B than being able to set off? Why do you want to be able to set off? It is cheaper, yeah. You don't want to have to bring proceedings against A. It's just cheaper for you to deduct that sum from what you owe to A. So you basically, in effect, get paid without having to do anything. And it can also be important if the other party is insolvent. Because if the other party is insolvent and you sue them, you're not going to get full recovery. But if they're insolvent and their liquidator or whatever sues you, then you can deduct the full set-off and you're protected. So set-off can be quite important, and it's conceivable that set-off might influence who you enter a contract with. So it could be, let's say you're X now, so you're X, and it could be that A already owes you some money. So you enter a contract with A, whereby you're going to owe some money to A, but you think, well, the advantage of contracting with A is then if A doesn't pay me the money they owe me, I can just set it off my debt to them. Okay, so it could mean that that person's a better person for you to contract with, really. So sometimes X might actually choose to deal with A specifically because they know they've got some set-off possibilities against A. Okay? So X owes this debt to A, but actually A also owes a debt to X, and X is therefore dealing with A, knowing that they've got this possibility to set off. Okay? Now the question then is, what's the impact of an assignment on set-off? Okay? Because you can see this might be a problem, because if A can assign now to B, and if that then prevents X from setting off the debt that A owes to X, that would be a problem, because before, like, A could sue X, let's say, for £5,000, but then X could set off the claim for £3,000 that they have against A. So if A sues X, how much money will X have to pay A? They're being sued for £5,000, but they can set off £3,000. How much money will have to pay them? You can use your fingers if you like, don't be embarrassed about using your fingers, it's fine. Digital world, after all. So they're going to have to pay £2,000, then you have to pay £2,000, don't they? They have to pay £2,000. Whereas if B sues, if B says, look, this debt was assigned to me, so now you have to pay me £5,000, then the problem for X is there might not be any set-off against B, because B's going to say, well, I don't owe X any money, so why can't I just get the full 5,000? So if assignment interferes with set-off, that's going to be a real problem for X. Okay? So the rule is, the first rule, this is on the handout, if X's claim against A, in our example of 3,000, if that arises out of the same contract as that debt, if these are part of the same contract, then you can always set it off against B. Okay? And that's true whether it's a statutory assignment to B or an equitable assignment. You can always set it off against B. But it could be that the claim arises out of different circumstances, as in the case where I run you over, but you owe me a debt independently. Okay? Now, if the set-off arises out of different circumstances, X can still rely on it against B, but only if the claim that you're setting off, the claim against A, only if that arose before notice of the assignment was given to X. Okay, so once X has notice of the assignment to B, once X has notice, then a claim that X has against A, which they could have used as set off against A, if it only arises after they get notice from B, and if it's not connected with the debt that X owes to A, then it can't be set off. Okay? And that's the business computers case. Business computers against Anglo-African leasing. So that is a bit of an issue potentially for X, is that an assignment isn't going to increase X's liability. We know that from the Dawson case and Linden Gardens case. But although your liability isn't increased, your chances of using a set-off can be reduced. But they're only reduced after you receive notice. And again, I think this is a balance between the sort of conceptual view and the contextual view, because you could say, look, conceptually, if it's really A's right that's being assigned, if that's what's happening conceptually, then X's position should be the same throughout, whether or not they get notice. You know, if it's really A's right that's being assigned, then surely the set-off that was available against A should always be available against B, because it's really just the same claim. That might be the sort of pure conceptual argument. But contextually, that would be a bit of a problem, because then B's in a position where they don't know what set-off could be used against them. And so the right they then get from A is of uncertain value, which is not a good thing. And so the compromise is the set-offs that are unconnected will stop after notice is given to X. So at least X knows that, and they can sort of plan accordingly. So it is a sort of compromise, really. But it's worth being aware of the set-off, because that is one of the few situations where X's position can be made worse off as a result of the assignment. Is there any difference there between equitable assignment and statutory assignment, do you think, when you look at those set-off rules? Do equitable assignment and statutory assignment operate differently? Is that important if you're being asked to compare equitable assignment and statutory assignment, for example? Yeah?
Well, the notice comes with statutory assignment anyway, doesn't it?
Yeah, exactly. So it doesn't really make a difference, because what's important here is there's been an assignment plus notice to X. So it could be an equitable assignment plus notice to X, or it could be a statutory assignment, which by definition has notice to X. I think this is one of the things you see in quite a few bits of the law, is that the equitable assignment plus the notice to X has particular effects. So equitable assignment plus notice to X changes the position on set-off. it also means that X is no longer safe in paying A. X now has to pay B because they've got notice. So equitable assignment plus notice to X can make an important difference. Okay, so I think you could argue the real distinction is between, on the one hand, equitable assignment, and on the other hand, equitable assignment plus notice to X. And statutory assignment is obviously always in that second one, because you have to have notice to X. So in some respects, the really important thing that changes the party's position is the notice to X. I think in some ways, that's the crucial question. Not so much whether it was an equitable or a statutory assignment, but rather, was notice given to X? You could argue that's the crucial question, really. Okay? Good, any questions on that? Set-off's one of those things that's very important in practice, but that you don't learn about at all at any point. Like most things that are important in practice. But you can pick it up, it's not that hard. Good, so prohibitions on assignment. Well, let's sort of set it up briefly and then we'll have a break. So why are limits on assignment interesting?
Because you can circumvent them using trusts?
Yeah, that's one reason they're interesting. One reason they're interesting is because if you have a clause in a contract, so this would be a clause in the contract between X and A, that says you are not allowed to assign this contract, you're not allowed to assign the debt, or if it's a contract that just in its nature can't be assigned, like the contracts in the Don King case, just in their nature they can't be assigned, then that looks like there's a problem. There's this right, there's this debt that X owes to A, let's say, or there's some sort of duty that X owes to A, but it can't be assigned. But the difficulty is A wants to make some money now by dealing with this right that they have against X. And so what they would do is they would ask their lawyers and say, look, what can we do? What can we do about this? There's this clause that says we can't assign it, but we want to get some money now. And so you want your lawyers to come up with a clever way of getting round it. Okay? And there are clever ways of getting around it, which is good. But the crucial question is, well, should we allow that to happen? Should we allow there to be these clever ways of getting around it? And again, there's sort of two aspects to this. One is the conceptual question. One is, like, conceptually, does it make sense as a matter of doctrine to allow these things even though there's a non-assignment clause? Okay? Should we let people do things that look pretty similar to assignment even though there's a non-assignment clause? And there are various aspects of that conceptually. So one argument that they made in the Linden Gardens case, one argument that A and B made, was to say we just shouldn't allow non-assignment clauses. As, conceptually speaking, they just shouldn't be permitted. Okay, what was the argument there in Linden Gardens to say we shouldn't allow non-assignment clauses? Shouldn't be allowed? Yeah, good, exactly. The argument was it would be a form of limitation on people's property. So A's got a right to sue X. That's a bit of property. People's powers to deal with their property shouldn't be limited. So, for example, if I sell you some land, transfer my freehold to you, but I say you are not allowed to sell the land, that's going to be invalid. I can't place that sort of limit on your powers to deal with your property. Okay? It's not going to stop you selling it. You can still sell it. It might be that you're breaching your contract with me and that I could sue you for breach of contract, but your sale to C is still going to be valid. Okay? So the Linden Garden argument is interesting because of what we mentioned last week. To what extent is a contractual right really property? And what's an obvious difference between a contractual right and a freehold or ownership of goods? That's true. The contractual right you can only force against X. That's true. Although when we're looking at assignment, what's happening with the benefit, it's still always X who's going to be sued. So that rule isn't being challenged on this question of assignment. So you're right, but I was thinking more about where the rights come from, about what creates the rights, where the contractual rights come from. Are there storks flying? Is it two people settle down, buy a house together, and then contractual rights arise? Where do they come from?
Contracts.
Yeah, contracts, because... But do they exist out there? Like land, goods, they're physical things, they're just out there in the real world. Where do contracts come from?
Mutual agreement?
Yeah, people agree. Okay? So the point about things like rights in relation to land are ones essentially that the law creates. The law says you can have ownership of that, you can have a freehold of that, and then the law gets to decide what it means to have a freehold, what it means to have ownership. And one of the things it means is you can then sell it. So the law gets to decide. Okay? Whereas with contractual rights, that comes from people reaching agreements. And so if the people creating the contractual right, they say it can't be assigned, there's quite a good argument for respecting that. Because the only reason we have the contractual right in the first place is because these people created it. And if they create it and they say it can't be assigned, then there seems to be a good reason for listening to that. And that makes it different from a freehold or from ownership of goods, because those rights weren't created by people, private individuals. They're recognised by the law. Okay? So in Linden Gardens, this is on page 11 of the handout, in Linden Gardens, Lord Brown Wilkinson, who's a good judge, he rejected this argument that a restriction on assignment is invalid because it's an invalid restriction on property. He rejected that argument. Okay? He says that's not right. And he didn't go on so much about the conceptual side of it. I mean, I think the conceptual side of it is just, it's not the same as ownership of goods, a freehold of land. It's not the same. That's what we talked about last week. But there's also a contextual argument, which is the point he makes. There's a legitimate commercial reason for limiting assignment. In this case, to ensure that you're not brought into direct contractual relations with third parties. And he's quite good on that in the case, Lord Brown Wilkinson. One of the few judges whose name can be abbreviated to a mode of dismissal in cricket. But he was saying that there are good reasons why you only want to deal with particular contracting parties and not allow free assignment. And what are those reasons? Why might you want to deal only with a particular party, not with other parties? What sort of things have we talked about? Sorry? Yeah, set-off's a good example. So set-off, and this is particularly true, Lord Bremerton was saying, in the sort of construction context, which is what Linden Gardens was about. Okay. So you might want to deal with that party because you know you have various rights of set-off against them. Okay. So you don't want to be put in direct contractual relations with third parties. So, you know, there's a conceptual aspect to the argument, but there's also a contextual aspect to it. And obviously the nice situations are always the ones where the conceptual arguments and the contextual arguments go together, and they sort of lead you to the same conclusion. That's always good. And there's both a conceptual and a contextual argument to say a non-assignment clause should be respected. It's different from an attempt to limit your power to transfer a freehold or your power to transfer ownership of goods. Those things wouldn't be valid. But a restriction on assignment of a contractual right can be valid, both because there's good contextual reasons and also conceptually, if it's the parties themselves who created the right, why can't they limit how it behaves? That's the argument there. Okay? But, contextually, there's a problem with non-assignment clauses. Contextually, there's a bit of an issue with them. And actually, a new thing, which won't have been in the lecture cast because they hadn't published it at that point, is the article by Gulliver and the others, which is on Moodle, it's on the reading, which is definitely worth looking at. And what do they do in that article, Gulliver and the others? Do they travel around the world? Do they get shipwrecked? Meet lots of differently sized people? Is that what happens? Or is that just a misunderstanding of two phonetically very similar consonants? What do you think that is? No? So what happens? The Gulliver one, well, they do sort of travel around a bit, it's true, and they ask people questions. So they're doing a sort of survey of what's happening in practice about non-assignment clauses. And in practice, non-assignment clauses do cause problems. Because you're A, you're the company, you want to raise some money. So you're saying to B, who's providing you with finance, look, give us some money and we'll assign these rights that we have to you. But the problem is there might be a non-assignment clause there. There's sort of different abbreviations that get used for them. I mean, in their arts they call it a BOA, like a ban on assignment. But that's not great because there's a case involving Bank of America. So that could be a bit confusing. Or sometimes I just call them non-assignment clauses, NAC. There might be a non-assignment clause. And then the problem for B is they want to give money to A in return for getting assignments of these contractual rights. But it might turn out there's a non-assignment clause. And then when they come to enforce it against X, it's not going to work because of this non-assignment clause. And then the problem is it makes life difficult for A to raise money. Because, as we talked about before, assigning the rights you have against customers is an important way for businesses to raise money. Okay? And there are ways around this, of course, but then that makes the financing more difficult to get. And what they say in their sort of surveys, it makes it particularly hard for sort of smaller businesses. SMEs, smaller businesses, small and medium enterprises, makes it harder for them to raise money. So contextually, there's a bit of a worry about non-assignment clauses. And so what has Parliament done about this? Again, this is probably after the lecture and the lecture cast. Well, there is now legislation. There was legislation that was passed. I must forget the name of the act because it is called something like the Small Businesses or Small Enterprises Act or something. Yeah, the Small Business Employment and Enterprise Act 2015. Very important. The Small Business Employment and Enterprise Act 2015 that gave the Secretary of State a power to pass regulations that would make non-assignment clauses ineffective. Okay? So in business contracts, you could put in a non-assignment clause, but it wouldn't be effective. It wouldn't prevent an assignment. Okay? And so the Secretary of State has power to introduce those rules. So it means that this debate about whether or not non-assignment clauses should be effective, it's got a very clear practical context to it. Because the Secretary of State now has this power to bring in these regulations that would render the non-assignment clauses ineffective. It would mean you could still assign these rights. And the reason for doing that is the government saying we want to help small businesses and we want to help them raise money by factoring, and therefore even if X, the customer, insists on putting in a non-assignment clause, that's not going to stop A later on raising money by assigning those rights to B. Okay? And there's a debate about that. Cowan and Richard, in his article, he says, well, the problem with that is it goes against freedom of contract. It's a very important principle of English commercial law that the parties should be free to set the terms of their own contracts. So why are we departing from that? Whereas in the Gulliver study, they're saying, well, these clauses can cause problems in practice. And they point out that lots of other jurisdictions also prohibit non-assignment clauses, or at least say the non-assignment clauses won't stop the assignment being effective. Okay? So there is a real practical aspect to this debate as well. So those things, the regulations, the Cowan article, the Gulliver article, they're all stuff that's more recent than from the lecture that I gave, I think. Good, so that's just to sort of set the stuff up. We'll have a break now for 10 minutes, shall we? And then we'll carry on to look at it. Is that all right? Good.